Marcus Ellroy did not look up from his phone. He was at the defense table, his client to his left, the prosecutor mid-sentence across the room, reading a series of messages he had opened a dozen times before. This time something had shifted. He read the third message again, then the fourth, then he understood what he was looking at, and what it meant for the man sitting beside him. He put the phone face down on the table. He had 48 hours before closing arguments. Marcus had been a criminal defense attorney for 19 years. He worked downtown, kept a small office, and had built a reputation for being methodical in situations where other lawyers became theatrical. His relationship with Detective Ray Harlan had begun when Marcus successfully argued, by the thinnest of margins, that evidence Harlan had gathered in a burglary case was admissible. Both of them knew it had been a close call. Neither of them spoke about it again. But after that, Harlan began sending things. Background on cases Marcus was working. Context on witnesses, on victims, on the history of whatever neighborhood a crime had taken place in. Information that did not always appear in the official discovery materials but that made a defense attorney's preparation more efficient. Marcus told himself it was informal consultation. He told himself he never asked where the information came from. He kept telling himself those two things for 12 years. Danny Patel was 24 years old. He worked maintenance at a hotel on the east side of the city and had no criminal record. He had been charged with manslaughter in the death of a man named Cordell Watts, who died outside a bar in October after a street fight. The state's case rested on one eyewitness, a man named Forsyth, who said he saw Danny throw the punch that sent Watts into a metal railing. Danny said he was not the one who threw it. He said Forsyth had been too far away, in poor lighting, already heading toward his car. Danny's mother called Marcus's office in November, using a name he recognized, a former client who had told her to call. Marcus took the case. He believed Danny from the first conversation. He also knew that Forsyth's testimony, if it held under cross-examination, would be very hard to overcome. Harlan had sent the messages the previous March, 8 months before the trial began. He sometimes did this with cases Marcus was working, background on witnesses, on victims, on the environment where something had happened. Marcus had read them in March as general context and filed them away. He had not thought about them since. On the third morning of testimony, during a recess while the prosecutor reorganized his notes, Marcus opened the message thread to confirm a date Harlan had mentioned offhand. He found the date, then his eye moved lower, to a block of text he had forgotten existed. It was an exchange between Harlan and Forsyth. Harlan had forwarded it to Marcus months ago, embedded in a longer document of background material. At the time, Marcus had read it as context about the witness's reliability. Now, reading it again in the fluorescent quiet of the courtroom, he understood what it actually was. Harlan had asked Forsyth where he was standing when the fight broke out. Forsyth said he wasn't sure. He'd been moving toward his car, maybe 20 feet from the entrance, maybe more. Harlan replied, "Could have been closer? Near the entrance? That would put you with a clear angle on the railing." Forsyth wrote back, "Yeah, I think so. That sounds about right." The exchange had taken place 6 weeks before Forsyth gave his official statement to investigators. In that statement, Forsyth placed himself near the entrance of the bar, with a clear angle on the railing where Cordell Watts had struck his head. Marcus spent the rest of the recess trying to find another way to read the exchange. He considered the possibility that Harlan had been clarifying, asking Forsyth to confirm what he already knew rather than suggesting what he should say. He read the messages 3 more times looking for that interpretation. He could not find it. Forsyth had expressed uncertainty. Harlan had offered a geometry. Forsyth had accepted it as memory. That was not clarification. That was construction. The recess ended. Marcus set his phone face down and watched the prosecutor resume his examination. He watched Forsyth on the stand, composed, measured, answering in the careful way of someone who had thought at length about how to answer. Then he looked at Danny, who was watching the testimony with the studied blankness of someone who had learned, over months of preparation, not to react. That afternoon, Marcus cross-examined Forsyth for 2 hours. He started with the lighting. The bar's exterior sign had been dark that night. Its ballast had failed, documented in a maintenance log Marcus had subpoenaed in October and the prosecution had not introduced. Forsyth acknowledged the sign was off, then mentioned a streetlight at the end of the block. The streetlight existed. Marcus had confirmed it. It was further away than Forsyth implied. But it existed. He moved to distance. He asked Forsyth to mark on a diagram where he had been standing. Forsyth marked a point near the entrance. Marcus placed the diagram against the crime scene photographs, letting the jury see the geometry, the angle from that position to the railing, technically workable but dependent on a location somewhat closer than Forsyth's earliest account had placed him. He let the jury see the gap. He did not underline it. He moved on. He also laid out the full timeline of Forsyth's evening, when he arrived, when the fight began according to the bartender's account, when Forsyth's 911 call was placed from his car. The call described hearing a fight, not watching one. Forsyth explained that he had seen the altercation first, then walked to his car, then called. The explanation was not impossible. The jury did not appear to find it disqualifying. Marcus sat down after the second hour and knew. He had watched the jury throughout, not their expressions during testimony, which could be read 100 ways, but the small physical adjustments. When someone leaned forward, when a pen moved, when a juror looked at Danny instead of at Forsyth. The cross-examination had created doubt. It had not created enough. Forsyth was not a perfect witness. He was a good enough one. The difficulty with cross-examining a coached witness, one who has had 6 weeks to absorb a suggested account as genuine memory, is that the coaching becomes invisible from the outside. The witness does not feel as though they are lying. They feel as though they are remembering. Forsyth's steadiness under pressure was not the steadiness of someone maintaining a fabrication. It was the steadiness of someone who had been given a story until it became their own. Marcus called Harlan from the parking lot outside the courthouse. They met that evening in a garage 2 miles away, which was where they had always met when a conversation needed to stay outside any official record. Harlan arrived in a dark coat, unhurried, hands in his pockets. Marcus walked him through the messages, not to explain what they meant, because both of them already knew, but to establish clearly that Marcus had understood them. Harlan listened. When Marcus finished, he looked at the concrete floor of the garage. "You can't use those," he said. Marcus said he understood the problem. "I don't think you do. Those messages came to you outside discovery. You produce them in court, you have to explain how you have them. You explain that, and we're not talking about this one case." Marcus knew what he meant. 12 years of communications, dozens of cases Harlan had worked, many of which Marcus had touched in one direction or another. If a court began examining how information had passed between them, what Marcus had received, when, what he had chosen not to examine, the answer would not look clean. He thought about what he stood to lose. His practice, the clients currently in county awaiting trial, Soraya, who had worked with him for 11 years, the standing he had built over 2 decades in a profession where standing took a long time to establish and very little time to forfeit. He thought about the cases in which Harlan's background had played some small role, and the number of those was not small, and he could not be certain, from inside his own memory, how much of what he had won over the years had been won entirely on the record. "He's innocent," Marcus said. Harlan didn't respond. "He's 24 years old. He didn't kill anyone, and the only reason a jury is going to convict him is a witness you walked through his own statement before he gave it." "I know what the case is," Harlan said. "Then you know what those messages show." Harlan looked at him, not with anger, but with the flat patience of a man who had already worked through every version of this conversation and had an answer for each one. "What I know," he said, "is that you cannot use them." He walked to his car and left without looking back. Marcus drove to his hotel. He sat in the room with the lights off. The city below was amber and gray, quiet at this hour, indifferent to anything happening in this room. He thought about Danny Patel's mother calling his office in November because someone she trusted gave her his name. He thought about Forsyth typing "Yeah, I think so. That sounds about right" on his phone, and then 6 weeks later standing in front of investigators and describing that same geometry as his own unassisted memory. He thought about all the times over 12 years that he had received a message from Harlan and put his phone back in his pocket without stopping to ask what he already suspected. Not asking, when you already suspected the answer, was its own kind of decision. He had made it many times, and each time it had been a little easier than the last. He sat there until the city began to lighten at the edges of the sky. He did not sleep. At 6 in the morning, Marcus opened his laptop and typed a letter to the presiding judge. He was precise about everything. He described when the messages had arrived, through what channel, and what he had understood them to mean at the time. He described what he understood now. He identified the exchange between Harlan and Forsyth that had preceded the official statement by 6 weeks and explained, in plain language, what he believed it demonstrated. He flagged the Brady violation. The prosecution had almost certainly not known the messages existed, which meant the failure to disclose was Harlan's, not theirs. But a Brady violation did not require bad faith from the prosecution to be a Brady violation. Then he kept writing. He described his own conduct, 12 years of informal communications with a detective assigned to cases he was defending. He wrote that he had received this information outside of formal channels and had not previously raised it with any court. He wrote that this was a failure of professional responsibility, and that he was disclosing it now because the alternative, allowing a jury to convict on testimony he had specific reason to believe had been shaped before it was ever given, was not something he was willing to do. He attached the messages. He submitted the letter before 7 o'clock, before Danny's mother had arrived at the courthouse, before Soraya had opened the office, before anyone who knew him had the chance to tell him to wait. The judge read the letter in chambers and called both attorneys in at 9. She asked Marcus 3 questions. He answered each one directly. By 10 o'clock, the jury had been excused. By noon, a mistrial had been declared. The prosecutor announced a review of the case. 3 weeks later, the office declined to refile. Danny Patel went home on a Tuesday afternoon while it was raining. Marcus was still in the parking lot when Danny's mother came through the courthouse doors. She looked at him for a moment without speaking. Then she put her hand briefly on his arm and walked to her son. The Bar Association notice arrived 6 weeks after the mistrial. It described the preliminary inquiry into Marcus's professional conduct related to the communications he had received from Detective Harlan. It was thorough and official and marked the beginning of a process that would take another 8 months to complete. Marcus read it in his office on a Friday afternoon with the door closed. Harlan retired before the internal affairs investigation concluded. 4 other cases were identified for review. 3 went to appeals. 2 of those resulted in retrials. Marcus gave a full accounting to the investigators. He gave the same accounting to the Bar Association. His license was suspended for 60 days. He returned to practice the following spring. He did not reach out to Harlan. He did not hear from him either. In December, Danny Patel sent him a card. It said, "Thank you for what you did." And on the next line, "I know it cost you something." Marcus read it twice. He put it in the drawer where he kept the things he wanted to keep. He still took cases others wouldn't touch. He still believed, in the way you believe in something after it has cost you enough that the belief can no longer be mistaken for comfort, that the work was worth doing. The bar notice had been, in one respect, his idea. In the cover letter he had sent to the judge that morning in November, the one he submitted before anyone he knew had the chance to suggest he reconsider, he had included a final paragraph requesting that the Bar Association be formally notified of his conduct. He had not told anyone he was going to do that. He had written the paragraph and left it in.